So my plan is to do three things in this kind of larger conversation about national security and civil liberties in the Trump administration. And I think the subtitle that Sid and I had discussed some months ago was, what can we learn from the first 100 days of the Trump administration? We can learn a lot. So my plan is to do a few things in discussing this. First, I want to talk briefly about the administration's kind of tactics and approach with regard to testing the limits of executive power. Second, I want to talk briefly about some aspects of counterterrorism law and policy that have actually retained continuity from the Bush administration to the Obama administration and now through the Trump administration. And third, I'll talk about some areas that have gotten a lot of news coverage, some of the executive orders that have been issued, and the challenges, the legal challenges to those executive orders, and then also the likely outcome of those challenges as they work their way through the court system. So I want to start with this, the discussion of accruing executive power. And this is something, obviously, that's been in the news a lot, including in the last 24 hours. But a lot of what the Trump administration has tried to do in its first few months in office is testing the boundaries of its own power and the resilience of institutional and democratic norms. And here I mean that in a bunch of ways. First, it's pushed outward on other branches of the federal government to see how much power and influence it can wield. So specifically in the national security realm, we see it pushing back on the idea that courts have the power to review actions that are taken by the executive branch if the president says, I am doing this in the name of national security. That has generally not gone well for the administration, and we'll discuss that in a moment. But we can see how it's attempting to push back on the judiciary's role in creating checks and balances among the branches of the federal government and to create more space for itself in the decision-making authority. In other areas, the administration has pushed against Congress to see who will fall into line with initiatives that the administration wants to push forward and who can be punished either politically or publicly when legislation does not pass. Specifically here with the healthcare legislation that's ongoing, you can see that dynamic working its way through the administration and people in Congress who are loyal to the administration and those who are not. I use healthcare as an example because it doesn't really need to do this in the national security front. Congress has already granted over the years so much unchecked power to the executive branch that they really don't need to push hard on Congress for anything more. So we see pushing outward on other branches of the federal government. The administration has also pushed downward and tried to test the boundaries of federalism, the dynamic between the federal government and the state governments. Here specifically with regard to the administration's promises to crack down on sanctuary cities, another thing I'll talk about in a few minutes, there's pressure being brought to bear along with very harsh rhetoric about what will happen to state and local governments if they do not comply with what the Trump administration wants to do, regardless of what the constitutional limits are on the federal government's authority to push down on cities this way. It's also pushed upward on the norms imposed by the international community, specifically in the national security sphere. We've seen them skipping meetings related to national security that have been convened by various bodies within the United Nations, skipping meetings dealing with border control and human rights in the counterterrorism sphere. It has questioned the value of intelligence sharing agreements among allied nations, or using sometimes the allies as perhaps a straw man about people who are surveilling President Trump or members of his administration. We see a questioning of organizations like NATO and the utility they can play in the national security realm. And in all of these contexts, we see the administration pushing against both international organizations and international law and norms. And then finally, there's a push inward. And this is what we've seen in the last 24 hours with the firing of former FBI Director James Comey. It's pushed on the administration and kind of disrupted a lot of ways in which the administration used to work in matters dealing with national security, among other issues. So initially, we see a reorganization of the National Security Council with multiple political advisors being considered integral parts of the National Security Council. That has shifted in the last few weeks to become a more regularized council, something that looks more like it looked under the Bush and Obama administrations. But we see the embedding of loyalty watchdogs in different administrative departments, including the State Department, the Department of Defense, the Department of Homeland Security, and other areas that are traditionally involved in national security decision-making. And we also see a distrust of the advice being given by the intelligence community. These are all extremely disruptive behaviors within the administration. And in that respect, the latest chapter in this saga, the firing of Director Comey yesterday, is simply part of a pattern of disruptiveness, right? The FBI plays a strong role in a lot of different areas. The one we've been hearing a lot about is the Russia-related inquiry. But the FBI plays a very strong role in domestic counterterrorism operations. And so based on political or personal decision-making, we see a lot of disruptiveness within the administration. And that pattern does not bode well in terms of national security decision-making. One of the things that came out of the September 11th Commission, that years-long investigation into what happened on September 11th, 2001, one of the main recommendations was to improve information flow between the various components of the intelligence community and the administration to make sure there was a more seamless operation of who poses a threat, how much of a threat, and why. And when you disrupt this many elements of the administration, you are disrupting essential counterterrorism channels and the implementation of those programs as well, right? Not just the information sharing, but the substantive counterterrorism programs as well. So all of these disruptions and these pushes on different aspects of checks and balances speak to a few things. So I think it speaks to the belief that President Trump has, and I think that this is an accurate belief on his part, that he was voted in with a mandate to disrupt business as usual, and he sees this pushing as disruptions that people have asked him to do. In addition to that, I think we see a skepticism towards expertise and knowledge that is developed and can be developed over years of study and work in a particular area. I think it speaks to a lack of knowledge and a basic indifference as to the basic functions of different branches of government and how they're supposed to work together. And I think it speaks to a lack of trust in both directions between President Trump and members of his own administration outside of his closest circle of advisors. And I don't think I'm saying anything that is particularly different than what the president would say himself, right? I think he has kind of flaunted his lack of respect for people who are in expertise positions over decades of work in different administrations, and has said publicly, I tend to go with more of a gut instinct, and I want to run this like a business, and in business you don't necessarily respect the people who are there for long periods of time. So I think this is what we see on a day-to-day basis in the Trump administration falls within this larger pattern, right, of pushing and disrupting different areas that have been traditionally considered constraining norms on an executive branch. So I want to talk a little bit about those are things that are different, but I want to talk a little bit about what things are the same, right, what things haven't changed. There's still certain aspects of counterterrorism law and policy that have remained very consistent between the Obama administration and the Trump administration. First, the prioritization of cybersecurity. This is still, under President Obama, it was declared a state of emergency in the United States, the situation with cybersecurity, and that has been renewed by President Trump. There is still an incremental program that's in place for the administration to try to shore up U.S. infrastructure to protect against cyber attacks, and also to proactively weaponize viruses to insert into non-allied nations' infrastructure and disrupt their ability to conduct the type of military work that they're doing. There is still an intelligence sharing relationship with the same countries that we've had the relationships with before. It is perhaps a little bit more strained than it was previously, but it's still intact. And for some of the substantive matters that the Obama administration had undertaken, the Trump administration is going forward as well. So things like targeted killings, the same framework for now at least is in place that the Obama administration used to use, is still in place for the Trump administration. For surveillance authorities, there's still an extremely broad surveillance authority both for foreign individuals, and then also for U.S. individuals who are red flagged for some sort of heightened surveillance. There is still the authority to engage in heightened scrutiny of certain populations within the United States. And specifically, it's fallen on the Muslim population or those perceived to be Muslim within the United States. It was used by President Bush. It was used by President Obama. It's still being used by President Trump. And finally, I'll just mention the detention facility at Guantanamo Bay. It's still open. There are no more detainees being sent there for now. President Obama had tried at least rhetorically, to close the facility there, and President Trump has suggested that he might send additional individuals there. The high water mark of the number of detainees there was 779 people. There's currently 41 there. And it's, I think, an open question as to whether more individuals might be sent there, or whether, as a matter of financial pressures, there might be some additional move to close the facility or shut it down. It costs over $7 million per year to house each detainee in Guantanamo right now. And there's some military commissions that are slowly grinding along there, with the estimated time frame for those trials being within 10 to 15 years. And it costs over $90 million per year to run those military commissions out of Guantanamo as opposed to our federal court system. So those things have remained generally the same. So let me take a few minutes just to talk about a couple of President Trump's national security actions that have been in the news a lot since January. And hopefully then we'll have some time for question and answer to discuss either these in more detail or other areas that people are curious about. So as everyone in this room likely knows, there was a series of executive orders starting on January 27th and the recent one on March 6th. And new instructions given to consular officers in March regarding screening of visa applicants in the name of national security, barring individuals of certain nationalities coming into the country, and barring refugees from coming in. And we see the start of what the courts at least have read as President Trump's promise of a Muslim ban manifesting itself in executive policy here, or at least the policy of extreme vetting, if we're not going so far as that ban. So I just want to talk briefly about these orders and what the current status of them are. The order that was issued on January 27th that I believe received a lot of press for how dramatic the unveiling was, and the immediate reaction of people going to airports and being stuck in airports. That order claimed it was done in the name of national security, right, in response to continuing failures in the visa entry system since September 11th. And it said, we have this combination of problems in the visa screening process, and we also have the issue of allowing in people who espouse, quote, hateful ideology that is anti-American. And so the order that was put in place was supposedly to meet these imperatives of general national security and keeping out people who are espousing anti-American ideologies and people from regions that allow honor killings. These were all in the text of that order. It called for a 90-day moratorium on people entering who were nationals of Iraq, Syria, Sudan, Iran, Somalia, Libya, and Yemen. And the idea here for these 7 nations were that the Obama administration in late 2015 and early 2016 had said anybody from whatever nationality who happens to visit those areas is perhaps at a higher risk of having some sort of interaction with a foreign terrorist organization. And so anybody who visits there who's not a US citizen would be subject to a heightened visa screening process if they happen to be a national of, let's say, the United Kingdom, a country that can often, the people from the UK can visit here without a visa. They're part of the visa waiver program. They would no longer have the benefit of those visa waivers if they had visited one of these countries. The Trump administration took that and did something very different in its January order. It just looked at the nationals of those 7 nations, regardless of whether they were living there or somewhere else, saying we're not going to let you in regardless of your visa status. But there was a loophole in the order that allowed people in on a case-by-case basis if consular officials deemed it necessary. And it blocked all refugees from entering the United States. The immediate effects of this were partly what we saw in the news, right? Kind of this chaotic unrolling and this lack of clarity as to who all was banned. Were permanent legal residents like green card holders also banned? That took a few days to sort out. There was all kinds of dramatic scenes at airports of people being blocked or turned away from foreign airports when they were at layovers, et cetera. And those were immediately challenged. And what happened in response were that plaintiffs brought a suit for a temporary restraining order, basically saying that they would suffer from irreparable harm if the Trump administration was able to go forward with implementing these orders. None of these cases actually decided the constitutionality of the ban itself, right, or of these executive orders. They only said there's a high likelihood that there's something unconstitutional going on here, that the plaintiffs would prevail eventually in their litigation. And the high likelihood that they would prevail, plus the irreparable harm of not being able to visit a country or being kind of labeled with the animus of something that seemed to be anti-Muslim, those were considered irreparable harms by the court. So there were a lot of cases that came out of that. And ultimately, the one that created a nationwide halt to the implementation of this executive order came out of Washington State in a case called Washington versus Trump. That order was issued by a federal judge there and upheld by the federal appellate court, the Ninth Circuit Court of Appeals. And that was challenged by the Trump administration. The reason that these temporary restraining orders were issued and that this ban was upheld was twofold, right? One was I think the idea that made a lot of news, the idea that there was something here that was distinctly anti-Muslim as opposed to something that was more neutrally applied. But the second part was that it was not helpful to national security, right? That it was actually irrational for the government to believe that this was a way to improve our national security. Because generally, when the president invokes national security, there's a very high level of deference that courts give, and this is an area in which the president is at his highest level of constitutional power. But it still has to be rational decision making, and it still has to be based in some logical changes that are being made. I'm going to take questions at the end, if that's okay. Are you raising your hand? Oh, never mind. It's okay. And the government's response was basically this. We are the administration, we are in the best position to know what is actually a national security threat and what is not. And so given that, the court should not look behind the order to ask whether this was really necessary or really useful. You just need to trust the executive branch that this was the right decision in the name of national security. And they also said, in terms of the religious discrimination, that there was no religious discrimination in the four corners of the document, and you really just need to look at that and not the larger context of what kind of language or promises or whatever else were made by then candidate Trump or now President Trump. That executive order, when it was kind of stopped in its tracks, led to a second executive order on March 6th that has the same basic premise, but is really much softer and much more thoughtful in the way it's couched, right? It no longer includes Iraq as one of these designated nations. It specifies which categories of visa holders will be denied and will be allowed entry. It's much more clear on who's affected. It no longer singles out Syria like the original order did for kind of indefinite suspension of the refugee program. Instead, the ban on refugees applies to everybody. It eliminates any languages about preferences for religious minorities that had existed in the first order. And it delayed its implementation by 10 days to give people time to understand what the order was about. This order looked a lot more like what you normally see coming out of an administration when it comes to changes in consular activity or visa activity. It's just toned it down a great deal. However, that was also challenged, and a nationwide temporary restraining order was also issued by a judge in Hawaii on March 15th, a day before it was supposed to go into effect. And then what happened on March 15th is quite interesting. The judge in Hawaii issued this order, and President Trump was at a kind of quasi-campaign rally at the time, and he kind of made comments about this judge, as he's been doing all along when judges have been disagreeing with him. And he said, well, this March 6th order was really just a watered down version of the previous order anyways. Maybe we should just go back to the first one and push forward with that. And it was based on that comment, that kind of watered down language, that the judge in Hawaii then converted his temporary restraining order into a permanent injunction against the Trump administration a couple weeks later. And I think this is a hard one for the courts. I don't think that the January 27th order was that hard for them, but I think the March 6th order is a little harder because it does look a lot more like what regular executive orders look like. And the judge in Hawaii said it's still tainted by the language and the rhetoric used by President Trump in suggesting that he wanted to ban all Muslims and suggesting that, you know, radical Islamic terrorism is what is going to undermine the United States, and therefore he needs to put a stop to it. And the judge there says, well, it doesn't mean that the president can never institute some sort of changes to the visa entry program. It's just that these changes at this time with that the context is, with the rhetoric, that's still problematic. But it's a much harder call. And we could see that just a couple days ago, 2 days ago on Monday, there was another temporary restraining order on the same March 6th executive order that came out of the Eastern District of Virginia. And the appellate court there, the Fourth Circuit Court of Appeals, was listening to whether they should leave this temporary restraining order in place, listening to argument. And the judges during oral argument were debating very strongly what the role of the courts is when we're dealing with a president who has made a lot of inflammatory comments on the one hand, but on an executive order that on its face, this being the March 6th order, looks kind of like other executive orders that they would generally allow to stay in place. How much does it matter what the president said? How long ago does it have to be before he issues an executive order and before between the comments and the executive order before it becomes okay and becomes an untainted order? How much should it matter what the intent was if the face of the order looks all right? So I think these things are ongoing, and that last question of how the courts are going to interpret their own role with regard to these executive orders is a very difficult one, and it's an ongoing one. It will get harder for the courts to push back against the executive branch in areas of national security if the orders start to look more normal, for lack of a better word, and less kind of slapdash or haphazard or motivated by animus toward a particular group. The last thing I'll say, because I know we want to get to questions, is I just wanted to speak briefly about another executive order that the Trump administration has issued with regard to sanctuary cities, which he has also done kind of in the name of national security. And he's done it the president has been very successful in kind of conflating national security with law enforcement and immigration, kind of low-grade anxieties that people might have, and he's kind of done a very effective job of pushing them together and saying, here's everything that you ought to be afraid of all in one. And it's a very deliberate maneuver to suggest that we're all very insecure because of a variety of foreign and domestic threats. It was very effective in his campaign, and he's still using it now to try to push through these executive orders. So the sanctuary cities orders are part of that domestic national security agenda. On January 25th, in an executive order that he issued late that day, said that these sanctuary cities are a threat to national security, and basically said that the Attorney General would have the authority to withhold funding to cities that did not comply with federal immigration enforcement orders. And in late March, Attorney General Sessions said that the Justice Department would claw back any funding that was awarded to a jurisdiction that violates federal law. This amounts to over $4 billion a year that he's talking about. And jurisdictions here were being told that they needed to, they would not be eligible for federal funding of programs if they could not certify compliance with a particular law that allows them to share information about immigration status with Immigration and Custom Enforcement when they make like a local traffic stop or a local arrest. So these actions are likely unconstitutional, right? This is a lot of harsh rhetoric coming out of the administration. But already one federal court in San Francisco issued a temporary restraining order in a case brought by the city of San Francisco and Santa Clara County, both of which stood to lose a lot of money if this were to go into effect. And the reason that the court thinks it's unconstitutional is that generally federal statutes that grant funding to states have to really state very clearly what the obligation is that goes along with that funding. Obligations like what Attorney General Sessions is talking about, they can't be added on later as kind of extra hooks that you have to comply with in order to get the money that you thought you already had. And then the other aspect of that is that the 10th Amendment, which is this protection in the Constitution that says that the states retain a kind of dual sovereignty with the federal government, it forbids what is called federal commandeering of the states. And so here, this anti-commandeering principle is supposed to prevent the federal government from forcing state and local police to do the work of the federal government. And it's really political conservatives that over the years have been pushing hard to preserve these anti-commandeering principles. The late Justice Scalia used to be a big proponent of states' rights in this regard, that they did not have to comply with the federal government. The most recent case that's upheld this principle came in 2012, when a bunch of states objected to the federal government's mandate in the Obamacare and the Affordable Care Act that suggested the Medicaid expansion needed to be implemented in order to qualify for certain federal funds. And that case said specifically the federal government cannot force the states to comply with it and cannot hold the proverbial gun to the head of the state governments by saying that they would withdraw funding. And so even though this kind of end to sanctuary cities is part of President Trump's domestic national security agenda, I think he's going to have a very hard time pushing that particular aspect through. Okay, I'm very cognizant that I've run over the 25 minutes that Sid kindly gave me, so I'll stop here and open it up for questions. Sure.
I can imagine Mr. Trump getting a court decision that he doesn't like, saying to him, well, you've made your decision, now let's see you enforce it.
Yep.
Do you see that as a likely part of the future?
Well, it's an interesting question, right? This idea of just refusing to comply with judicial orders. I think there was some fear that might happen after the temporary restraining orders were issued with that January 27th immigration-related order. There was worry that the Trump administration would simply tell Customs and Border officials to just keep going and not respond to the judicial order to step down. And there they back down. And I think the question, this goes back to the first part of my remarks about pushing on the different institutional constraints that exist and the Trump administration seeing how far it can get. I think that there's some hope in the fact that that there seems to be some objection by Congress and by the courts, and this willingness to stand up even when the president uses very kind of harsh, even somewhat bullying rhetoric in the way he describes these other institutions of government. There's some hope that their willingness to stand up in the face of that would bode well for that kind of constitutional crisis that you describe, that there might be some movement towards political pressure to either get President Trump to comply and back down from a statement that he won't actually follow through with what the courts are telling him to do, or political movement towards preventing the rest of his agenda from going forward in a way that could kind of push some levers and get him to cave. I think those are all intermediate steps that would come way before something very harsh like a censure from Congress, or even a move towards something more formal like impeachment. I think that more likely you would see political pressure being brought to bear to try to get him to back down, to see that in the long run it does him no good to have that kind of rhetoric or his refusal to comply with other branches of government.
You indicated that a sequence of events with regard to the March 6th executive order concerning immigration was that on March 15, the Hawaiian judge issued a temporary restraining order, and that subsequently Trump made comments about it, either tweeting or whatever.
Mm-hmm.
And that
Yes.
My question is, was there some justification for the conversion to a permanent restraining order, other than the judge saying, you know, I just don't like this crazy president, and he's a nut, and I'm going to make it into a permanent order?
Yeah, that's a very good question. So I think that in the first instance, what happened is that this March 6th order was issued, and it was issued with an implementation date of March 16th. And again, many executive orders among many administrations are rolled out this way, with a date of issuance and then an effective date, so that agencies and the public can get used to the idea of what's coming their way. So when the plaintiffs in that particular suit came forward, and this was the state of Hawaii was suing along with individuals who were residents of Hawaii who would have been specifically affected by the order, the initial TRO, that temporary restraining order on March 15th, is given on this kind of instant notion of that there is a high likelihood that there's something unconstitutional going on, and that there's an irreparable harm that would be suffered by these individuals, right, the state of Hawaii and the individual plaintiffs. And the idea of the temporary restraining order is, I'm going to put it in place for a couple of weeks, and in the meantime, both the government can make a case for why this executive order should be allowed to be implemented, and the plaintiffs can further flesh out what their arguments are for why they would be irreparably harmed. So all that briefing took place between March 15th and March 29th, the date that the temporary restraining order became permanent. Now, those arguments, the government used, I think, probably the best arguments that they had, that this was done in the name of national security, that it was a much more tailored and clear argument than the previous clear order than the January 27th order was, and that it was done in order to meet some security goals. And again, this kind of repetition of the idea, and this is an accurate idea, that the executive does have a lot of power when it comes to national security decision making. In the same period of time, the plaintiffs, the state of Hawaii and this individual plaintiff, could make better arguments or more fulsome arguments as to why this was not rational. And they had a bunch of kind of national security experts from both Republican and Democratic administrations say this does not make any sense as a national security matter. There were briefs that were filed to that effect. And then also talking about the religious harm element, or the religious animus element. And there, that's why President Trump's comments, referring to this as simply a watered down version of what he really wanted to do, were helpful to the plaintiffs to say, you know what, this is really this Muslim ban that he's trying to implement here. It's not based on national security concerns. It's wildly over-inclusive in terms of labeling all individuals who are nationals of these countries as potential terrorist threats. And it's also wildly under-inclusive. There's a lot of other people who are terrorist threats out there. They are not being targeted, right? This is an irrational way to go about constructing something if what you're really trying to do is preserve national security. So they're able to flesh out those arguments much more in those 2 weeks. And then the court had to decide anyways. By the time, I mean, its temporary restraining order there was a 14-day order, and it had issued it on March 15th. So it had to, by March 29th, decide something. So it had had the benefit of these arguments on paper and also oral arguments before the court with the Department of Justice and the plaintiffs' lawyers coming in. And so it wasn't just on President Trump's tweeting and public rally commentary. But those things certainly didn't help him, particularly with trying to dissuade the judge from thinking that this was motivated by anti-Muslim animus. So altogether, that court used all the information before it to make that March 29th decision, and that's up for oral argument in the federal appeals court again, and I think that's coming up next week. They're going to have oral argument there. All of this has been very fast-tracked due to the nature of what we're talking about. Yes?
This is from perspective of a business person.
Sure.
Use the words word norms and disruptive in your presentation. Oh, you did a very good presentation. Obviously very well informed.
Thank you.
Use norms and disruption in your presentation. And use norms in a good sense and disruption in a bad sense. Well, in my opinion, norms, I don't like norms, and I like disruption.
Sure.
In other words, if I have an
Mm-hmm.
So when describing Washington and use terms that the norm is to respect the person who's been there for a long time. Well, sometimes they're not doing their jobs.
Mm-hmm.
What is your opinion that Washington is too disruptive and should be respecting the norms more, or is being disruptive and not respecting the norms a good thing? It's going to involve change. Everybody complains about the government and Congress and all that. Anyway, enough from me. I'd like to let you know.
So, I mean, it's a fair question, right? And I think this goes to what I said earlier, that I think President Trump came in with a feeling that part of his job was to be disruptive and to be someone who breaks the usual pattern of what happens in Washington. And so I don't actually have an opinion as to a lot of aspects of how he's done that. And he's disrupted a lot of things in the first 100 days and change since he's been there. I don't have a strong opinion as to those things, but I think there's a difference between those norms which perhaps reflect poor decision making that's gotten calcified over the years and that needs to be disrupted, and breaking those norms that might be there for a deeper reason that requires a little bit of listening and understanding to understand why the norms are in place. And I have no particular opinion on what percentage of President Trump's decisions fall into one category and what fall into another. I will say that things like claiming that the judiciary does not have a role in overseeing national security matters, that they should have no say in what the government or what the administration decides. The president has every right to, as a human and as an American, to say this under the First Amendment. It is really a violation of longstanding norms to respect the fact that there are other branches of government. There's a difference in my mind between saying, I think the court came out with the wrong decision, and saying, I don't think the court had the right to look at it at all. And so I would view those as two very different things. And if President Trump had perhaps spent a little bit more time either reading up on it or talking to those in his administration who could help, they might suggest that post-September 11th, both the Bush administration and the Obama administration repeatedly said to the courts, you shouldn't look at this at all, right? This is a national security matter. You're not supposed to touch this. And the courts have really from 2003 onward said that's just not true, right? We will give you a lot of deference, but that doesn't mean we don't look at these matters and think about them. And so the norm here, the norm being broken is not him suggesting he doesn't like what the court did. I think presidents do that all the time, right? Democrats, Republicans, whoever. The norm is suggesting they don't even have a job to look at it. And that when he doesn't like the decision that's being issued by a court, to suggest that the judge is not legitimate, right? To suggest that this person is a so-called judge, or suggest that a person should not have the ability to hear a case because of their background or whatever else. Those, again, nothing about that is against the law, but they're breaking a lot of norms in terms of what we respect in terms of our separation of powers and checks and balances. Certainly I agree that some norm breaking and some dynamism is what's required in lots of institutions that are older and have calcified in certain ways. Certainly President Obama was elected on this theory of change and whatever else. In using different words and rhetoric, President Trump was elected on similar themes of wanting things to occur differently. But there's the way in which they're approached, and there's this notion of respect for the existence and role of certain branches of government that I think is fundamentally different here. Sure.
Yeah.
Was there, yeah.
I have two questions. One refers to the declaration regarding monuments. Those monuments were declared due to very old law. Theodore Roosevelt took advantage of that and he declared certain monuments. Like that, Obama also has declared monuments. But is there any mechanism for Trump to reverse those monument orders? I thought once those declarations were there, they could be modified to some extent, but not totally abrogated. Second question is about the many states have medical marijuana laws, and also recreational marijuana laws. Now, Jeff Sessions came out saying that federal law will be supreme, and federal law doesn't allow. Previously, they were not enforcing the federal law, but there seems to be a change in the thinking of the new Department of Justice. What is your take on that?
Okay, so these are a little far afield from the field of national security, but I'll do the best I can. With the monuments, you're correct that this law has been in place for a really long time, and that no president has ever fully undone the decision of a previous president to mark something as a national monument. And President Trump in the last few weeks has indicated that he would like a review of all of those areas designated as national monuments or protected spaces in order to take a closer look at them with the I guess, intimation that some of them might not stand under review, because why else would you be reviewing them? So I think that there has not been any case law or old precedent that we can look at to help guide us on what the courts might say in this area, because it's never been done before. But my guess is that there might be trouble in undesignating some of these areas, because once something has been designated as a national monument, the people who use that space then have access to that space and the use of it in a way that over the years the court has interpreted as individuals having a kind of personal interest in the use of public space. So if Yellowstone National Park was sold off to a developer next year, there would be a lot of people and other non-governmental organizations that would have the ability to challenge that and suggest actually, these are things that people have been using for the benefit of recreational use and for environmental reasons and whatever else. And that would be something new for the courts to hear. But my guess is that there would be it's not like a property interest in the sense of like your land or a car or something, but a property interest in the sense of the use of this public benefit for individual use. And that would be the basis of the challenge for that, that it is an unconstitutional deprivation of people's use of the monument. So my guess is that those challenges would come if President Trump tried to undo these these monument designations. As far as your second question having to do with medical and recreational marijuana, you're exactly right. This federal statute criminalizing the use of both has been on the books for a really long time. And the Supreme Court heard a case in 2005 questioning the federal government's authority to regulate things like medical marijuana and to criminalize medical marijuana when states had decriminalized it. And that Supreme Court case held that the federal government had the right to do that, saying that it was linked to Congress's power to regulate interstate commerce, and that marijuana is part of interstate commerce, and therefore they have the power to regulate it. So I think here there's two questions, right? To what extent will Attorney General Sessions actually follow through with the rhetoric of cracking down on medical marijuana? I know he's talked a lot about cracking down on recreational marijuana. I think there's a much wider societal acceptance these days of medical marijuana. So I think that that's a more iffy area. And I think the second question is, if he does start to crack down in this regard, whether we'll see a response from Congress. There's enough states in the United States that have now allowed for medical marijuana that you might see a political response to this in the form of Congress suggesting the decriminalization of marijuana for medical purposes. I don't think, this is just my personal opinion, I don't think you have enough political power yet to push for a protection of recreational marijuana, but I think there's probably enough there to get some protection of medical marijuana. And enough years have passed seeing the benefits to certain individuals with certain conditions that have not been treatable through other means. Yes, go ahead.
I thought we were going to hear something about cybersecurity. Are you concerned about, we're hearing much more about cybersecurity and hacking. Are you concerned, or do you think we should be concerned about it?
I absolutely do. I think that Cybersecurity has been an ongoing issue, and I think the number of vulnerabilities in the U.S. governmental infrastructural system are still very high. I think that the U.S. has invested in the last, say, 6 years, and that investment is continuing now, in recruiting more people to improve the defense of the U.S. cybersecurity infrastructure. But I think there are so many aspects to it that are still vulnerable that I think it is a big concern. In some respects, we hear about hacking and data leaks constantly. I'm actually impressed that we don't hear about it more. I think that there have been some improvements that have been made, particularly to sensitive information held by the government, but I also think the US government was a little bit late to the game on this, that they should have been planning for it more and investing more in terms of resources and people with expertise and paying them the market rates for their expertise, which they were not doing for many years. And that it's starting to become better, but there's still enormous vulnerabilities in the system. I think that's why it's still a continued state of emergency, which basically means from a legal perspective that if the president sees that there's an immediate need to funnel more funding or more resources towards something that seems to be an immediate cybersecurity threat, that he has the authority to do that. And as I mentioned earlier, President Obama put that state of emergency in place, and President Trump has renewed it, because I think they are both, President Obama when he was president and President Trump now, are both extremely concerned that this is a major area of vulnerability.
At the beginning of your talk, you suggested that the Trump administration was well organized and thoughtful in their rebuttal of Obama's executive orders. I suggest it was much more chaotic than that. It was reactionary and not purposeful.
I'm sorry, could you just repeat that? I just want to make sure I understand the question.
You said that the reactions of the Trump administration to executive orders and so forth was very well organized, pushing back purposely, purposeful. My suggestion is that it was much more chaotic than that. It was not well planned at all. It was just reactionary.
The people who were responding to the Trump administration's orders?
No, the Trump administration itself.
So gosh, I hope I didn't misspeak on this. I think that their efforts were very purposeful in trying hard to push back against the other branches of government. I don't think that they were particularly well planned out or thoughtful in the manner in which it was executed, at least in the first couple of weeks. But I think that it was a very deliberate decision being made to be disruptive, whether in the good way or the bad, right? But to be disruptive and to push back against the types of constraints that normally exist from other branches of government, from the international community, from the states and local governments. I think it was a concerted attempt to do that. I think the manner in which it has been done has, and whether this is purposeful or not, has been kind of extreme and been very, very provocative in the way that it's been done. Yes.
Yes, how secure or threatened do you feel our general system of government with its checks and balances and the three basic departments working together? How do you feel about its future?
So I think I feel pretty confident in the way that the judiciary has behaved thus far, in terms of being thoughtful in both its approach to the problems that have been presented to it and the substance of the decisions that have been being made. In all of these decisions, the Ninth Circuit, the Fourth Circuit, there's certainly people who think that the Trump administration is within its power to exercise its authority this way. They're dissenting opinions or, in oral argument, some debate among the judges. But even then, it's been a very thoughtful debate. They've been thinking deeply about the nature of executive power when it comes to national security and the idea of what the role of the courts is in navigating that. So I feel pretty confident that the courts are doing their job. In terms of Congress, I think that, as one person previously suggested, there's a lot of dissatisfaction with Congress over many administrations. This is not something particularly new. Congress tends to be a very political animal, and I think that it will be interesting to see in the next year or so whether whether the parties retain the kind of party loyalty that they've had thus far in the Trump administration, or whether that shifts over time as House members look to their own re-election campaigns gearing up for 2018. I do wonder whether we'll see a different tone being struck. And I think that there's a sensitivity to that was very well used by the kind of Tea Party folks back in 2009 and 2010 to put pressure on Congress to behave in a certain way. And I think you see folks doing something similar who are perhaps in opposition to the Trump administration's decision making, putting pressure on their Congress people. I don't have that much confidence in a lot of those Congress people themselves, but I have more confidence in the political process and the pressure that might be brought to bear on them by the public. In terms of state and local governments, I think they have a good amount of protection that has come up over the years from federal government overreaching. And the irony of it is that the politically conservative judges who have been appointed to the lower courts and to the Supreme Court are all people who believe very strongly in states' rights and protection of the states against federal government overreaching. So I don't think that you're going to see kind of collapse of that due to political pressure. I think those judges will stay true to their political philosophies or their judicial philosophies in keeping the federal government in check and allowing the states and local governments to have a little bit more breathing room, particularly on the sanctuary cities question. Sure.
One more.
Okay.
So this week, a reporter, 30-year veteran of public broadcasting, was arrested for posing a question to Secretary Price.
Yes.
And in addition, we're faced with fake news. Can the president have power at some point to say, well, in the face of national security, we need to put some limits on our freedom of speech?
Yeah, this is a good question. This reporter, I think, was arrested while wearing press credentials openly and whatever else, which made it all the more surprising when he was arrested. I believe it was on like the Capitol Police in Charleston or something, right, arrested him when he was posing a question to Tom Price, the Secretary of Health and Human Services. And, you know, one thing that that has been a very good protection for reporters is these First Amendment protections that are deeply embedded in our constitutional fabric. And I don't see that going away anytime soon. I think that if President Trump attempted to silence the press in some way, and this includes arresting press members, and it's not to say that the president had any part of this, you know, just well, as far as we know, it's just the Capitol Police who had taken this action, that there would be a very strong pushback from the courts. And this has been true, I think, across administrations as well. In the Bush administration, there was some attempt to silence reporters on certain topics. The courts did not look kindly on that. In the Obama administration, there were attempts to prosecute or investigate reporters who had worked on stories that whistleblowers had brought to light about misspending and malfeasance in administrative agencies, and the courts did not look kindly on that either, right? So I think that any attempts by any administration to kind of quash the press are not seen as they will not be successful in the courts. By the same token, however, the same First Amendment protections afford a lot of leeway to falsehoods being published and whatever else by various bloggers and other outlets. And so, you know, freedom of the press cuts in a lot of different directions.
Thank you very much.
Thank you very much.
And we have a present for you.
Oh.
This is Never Look an American in the Eye by OK and Dibby, who is one of our previous speakers.
Oh, wonderful.
So we hope you'll enjoy that.
Thank you so much.
That's
lovely.
very much. Again, we have one more program this program season. We have our Adventure in International Dining. Pretty soon we think we're going to have our annual meeting in place, and then more instant issues are going to be scheduled for the fall. So keep an eye out for us, and thank you very much for coming.